Hi there, everybody. We're here today with Fletcher Rush at Williams-Parker, and we're talking about something that people don't like to do, and that's estate planning, right? So we're here, and one of the first questions, I think, is what's the difference between a trust and a will?
Mm-hmm. Yeah, estate planning is the bottom of the list, as I always say. Usually clients moving to Florida, they will meet with their financial advisor and establish other relationships, realtor, buying real estate, and then once everything else is done, find their way in to see me, but happy nonetheless. With a will and a trust, the difference, I think the starting point is to understand what is a last will and testament. And that document is something that is given to the court after I pass away. It has legal significance only after I'm gone. And what it does is it says who's in charge, who's going to settle my final affairs, who receives benefits, who's a beneficiary, how we pay bills and taxes. And that process, all of those interests are settled through the probate process. And usually when people are asking about a trust, it's because they say, well, how do I avoid probate? How do I avoid that process, right? Avoiding probate is a big term in this area.
Yeah.
And often it's a revocable trust is a thing that we use as a substitute or in addition to a last will and testament. And so why does a trust work? Well, the unique thing about a revocable living trust, which is the primary thing we do, a living trust, is that it continues to grow during my lifetime. I can change it just like I would during with a last will and testament. But when I pass away, its existence continues on. I can, during my lifetime, I can put assets into the name of my trust. I'm the trustee, I control them. I'm the grantor, I can change my trust. But when I pass away, the assets that are in my trust continue on in that form of ownership that I've created, this trust relationship. And so it's that fact, the ability to transfer legal title into the trust, that allows the trust to exist without needing to have a court step in, a probate court, to show that, okay, we know that this was owned by Fletcher and he's now deceased. It was in Fletcher's trust, and now the trustee is married. And so that allows us to continue on without having to go through the court process.
Tax benefits. I know people have talked about tax benefits and opening up trusts. What are the tax benefits, and are there actually tax benefits? Sure,
that's a really good question. I think the most common tax concept that comes in with estate planning is the basis adjustment when someone dies. The rule is that if I own assets or I control them, when I pass away, the basis for tax reporting is adjusted to the fair market value on the day that I die. And so this is the rule in real estate that allows me to sell a homestead property that someone's owned for 50 years for no gain after they pass away, right?
Great.
It's wonderful. Yeah, I mean, there's nice exclusions that are out there for income taxes, but this one is as good as it gets. You just have to, unfortunately, you have to die to get it, as one of my tax professors always would say. So that rule, the basis adjustment rule, is available if I own assets in my personal name or if I own them in my trust. And it doesn't really matter one way or the other. Some of the tax planning that you'll see in this area is really geared more towards irrevocable trusts, which are less common but are very important in estate planning. The downside of those is that I don't have control. If it's an irrevocable trust, I can't freely amend it, I can't freely revoke it. I'm giving away control, actually. That's a really important concept. That fact allows me to make powerful gift and estate tax planning decisions, but it might not be as helpful for other things I want to do in my estate plan. So it's a very nuanced topic, but
that's why you need a professional to come in and sit down and discuss the different, the pros and cons. Do you think that there's a milestone in life where someone should come meet with you? Like, I'm in my mid-50s, I know that I've sat down and we've talked about it, but is there a place where someone should definitely say, I should meet with an estate will planning trust?
Mm-hmm. Yeah, absolutely. I think there are several different areas where, or life milestones where clients might be more in need of an estate plan. I see younger clients that come in that have minor children that need to name a guardian, that want to have a trust because it's a convenient way to leave life insurance or retirement benefits in some cases. For myself and my wife, that's what we did. I'm in the business, of course, but also it's good planning to do because you don't want to just name your minor children on like life insurance benefits,
Yeah.
generally. So it's a little bit smoother process. But by far, most of the clients that we see in our office are new Florida residents. They're trying to establish Florida residency, maybe leaving New York or Illinois or somewhere that's a higher tax jurisdiction. And so part of the Florida domicile planning is to create your estate planning documents in Florida, because it shows a commitment here, just like having a driver's license and vehicle title and a homestead exemption, all shows that you're a Florida resident.
And you can work with those attorneys out of state or start fresh. There's lots of different options on what you can do.
It's very specific to what the client needs. In some cases, we're very focused on state income tax planning, and so we had to have co-counsel in another state to make sure that that's all done thoughtfully. And if there's real estate that clients have in another state, then that's something that we should try to pay close attention to as well.
Yeah, and I know you very well, and I know how thorough you are. So you would be, anybody that would work with him would be in excellent hands.
Thank you.
Where should somebody start? Like, what's the first thing someone should do? Like, I want to do this. What's the next step?
Sure. I mean, I think you need to be able to answer a few basic questions. Obviously, I can't name beneficiaries for you, so you have to know what you want to do after you pass away. But if you're not sure, I think we can have a collaborative discussion about it. We usually use a worksheet that helps clients get to the point where we're ready to meet. And if you don't have existing documents, then that's a great place to start. If you have existing documents, someone who's moving to Florida, for instance, then we could start by just reviewing what you have and not reinvent the wheel. Just let the discussion grow from what you have on paper already. And while I'm thinking about it, one of the most common issues that I see with clients is that they have, in the context of people moving to Florida specifically, they have Florida real estate that they owned before they were Florida residents in trust. Let's say I have a trust, my wife has a trust, I put a condo in Florida in my trust, and then we move to Florida, and we don't always update our trusts when we move. And you would think that, well, not a big deal, I just moved. Well, it can be an issue because there are very nuanced rules regarding Florida homestead, what I can do with my property when I die. And if I haven't addressed that in my trust document, then I may have created a problem, actually. So milestones to consider: changing residency, establishing Florida residency for a number of reasons, not just income tax planning, is a good thing to think about.
Excellent. Well, if anybody has any questions, we're going to find Fletcher's contact details below, and we'll see you on the next one.